Greetings and welcome to the third module of Management 3320, Human Resource Management. This module actually kind of contains two distinct kind of separate ideas. The first is the idea of equal employment opportunity, and then the second is workplace safety, workplace health and safety. The equal opportunity stuff is probably 2/3 of the module, and the safety stuff a third, or maybe even a little bit less than that. So here we go. We start off with the equal employment opportunity stuff. So your textbook says that the purpose of equal opportunity laws is to ensure that all individuals have an equal chance for employment. That does not sound right to me at all. It is certainly not the case that all individuals have or even should have an equal chance of employment. For example, hiring someone because they're smarter than someone else is perfectly legitimate. People who aren't as smart as other people don't have an equal chance of getting jobs. Hiring someone because hiring someone to deliver pizzas because they have a driver's license and choosing not to hire someone who doesn't have a driver's license would be perfectly legitimate. So it is not the case. It is not the case at all, and I really don't think I'm overstating this. It is not the case at all that the purpose of EEO laws is for all individuals to have an equal chance for a particular employment. That is not true. I kind of forced myself to rewrite this since it does seem so absolutely wrong to me. This is the way I would describe equal employment opportunity laws: is that their purpose is to ensure that only valid hiring criteria, only valid criteria, are used in employment action decisions. So since I muddled over that, let me try that one more time. The purpose of equal employment opportunity laws is to ensure that only valid criteria are used in employment action decisions. And so employment action decisions are hiring, termination, putting someone on probation, changing someone from one job to another job, demoting someone, changing someone from one shift to another shift, cutting someone's pay, increasing someone's pay. So the kind of fundamental things that relate to the employment relationship. That first one, I'm not sure whether it's right or wrong, but even if it's somehow right, and I don't think it is, but even if it's somehow right, it's a terrible way to say it. So this is a much better description. Ensure that only valid criteria are used in employment action decisions. And so, when we look for sort of the sources of equal employment opportunity law in the United States, we look to several things. We certainly look to the United States Constitution in at least a couple ways that I'll look to that we'll point out on the very next slide. It's also the case that all of the state constitutions contain something about something that's in some way relevant to equal employment opportunity. Here in Texas, we do have at least one, maybe more than that, provisions in our state constitution that are very relevant, and so I'll highlight those as well. We look to statutes both at the federal level and at the state level. At the federal level, virtually all of the equal employment opportunity statutes are contained in the Labor Code, and actually the same is true in Texas for Texas state employment law. It's the Texas Labor Code. Third are regulations. Regulations are rules that government agencies write based on some authority that they get from a statute that sort of provides some implementation and some additional details and additional definition and additional how-to related to implementing the statutes. At the federal level, statutes are contained in the Code of Federal Regulations. In Texas, administrative rules, regulations are contained in the Texas Administrative Code. We have also executive orders, which are kind of a type of regulation, a type of administrative law, but they're ones that come from the president at the federal level or come from the governor at the state level. And of course, we have court decisions because here in the United States we're based on a common law system. When a court makes a decision in one case, that decision has some precedential value for the analysis of future cases and future controversies. And so in that way, court decisions themselves are also an important source of law. It might be the case that treaties, which are the last of the main American sources of law, might be the case as well that treaties provide some insight. I couldn't think of an example, thinking about it for a few minutes this morning, so I don't know that it's true or not, but it certainly could be the case that a treaty might provide a source of equal employment opportunity law as well. There are probably a few places in the United States Constitution that sort of implicate themselves in equal employment opportunity issues. Privileges and Immunities Clause, potentially the 13th Amendment, but certainly the one that's the most important for us are the two protections guaranteed by the 14th Amendment. And so the 14th Amendment first guarantees or I should say forbids, the first forbids states from taking life, liberty, or property without due process of law. And so this would be relevant, for example, to public employees, because this is about the states. This would be relevant to public employees who would potentially lose their job working for the state government or even for a municipal government, which is a subdivision of the state, because one has a property interest in one's job. There's you get money for it. Money is property, and so when a state employee, government employee, loses his or her job working for the government, there needs to be some process, some fair process to make sure that the basis of that employee's termination is a legitimate basis. This comes up with some regularity. Most of the cases that you see involve public school teachers, but certainly any public employee would be relevant to that. And the second one is from the 14th Amendment, is the prohibition for states from denying equal protection under the law. And so we'll spend some time talking about this idea of equal protection in a little while in the context of one of the statutes. But in the United States, under this part of the 14th Amendment, we generally understand this idea of equal protection to be a right that applies to groups. So they are the characteristics like race, color, religion, sex, gender, national origin, those kind of things. And so, for a state, if a state government, state agency, city government were to use race as the basis in a hiring decision, or use gender and sex as the basis in a hiring decision, that would be prohibited by the Equal Protection Clause of the 14th Amendment. So the thing to note from that third bullet is that the 14th Amendment is only about what the government can do. It does not affect it does not affect private employers at all. So it does not prohibit private employers from terminating someone without due process of law. They certainly can. In fact, they absolutely can. It does not prevent private employers from denying equal protection under the law, though we have some statutes that we're going to talk about in a little while. That do prohibit employers from denying equal protection among those same protected groups. But the 14th Amendment itself is only about actions that the government takes. So folks will often ask, why is it that the Equal Protection Clause in particular is about group protection rather than individual protections under the law? So if you think back to I guess it would be the very beginning of the second U.S. history class, or the middle-ish of the American government class in the political science department, you'll recall that the 13th Amendment, 14th Amendment, and 15th Amendment are what we call the Reconstruction Amendments. So they were amendments to our Constitution that were ratified specifically in response to the Civil War, specifically in response to there no longer being the presence of slaves in the United States, at least not under the color of law presence of slaves in the United States. And so when this was written, this guarantee of equal protection under the law, it had African Americans in mind, right? It had African Americans and specifically former slaves in the South in mind. And so, even though the language of the amendment itself seems to suggest that it might be about equal protection for everybody as individuals, the context of it just tells us that that's not the case. It's part of Reconstruction. It's part of us figuring out as a nation how it is we're going to deal with beginning to overcome our original sin of slavery. And so that's why that equal protection clause is interpreted as a group protection, or at least an analysis from the perspective of people's memberships in groups than it is an individual right. In the U.S., all 50 states and all of the territories as well have constitutions of their own. And Texas is no exception. The Texas Constitution, there's a number of provisions in the Texas Constitution that are relevant, could be implicated by equal employment opportunity questions. The most significant is the Texas Equal Rights Amendment, and this was ratified in Texas in 1972. And so it's the relevant part states that the general, great, and essential principles of liberty and free government be recognized and established. We declare equality under the law shall not be denied or abridged because of sex, race, color, creed, or national origin. This amendment is self-operative. So that last sentence, this amendment is self-operative, just means that the legislature didn't have to make a statute to make this become the law. As soon as it was ratified, it became part of it, became our law. And so, what's the big deal, right? You look at that sure sounds a lot like those kind of group-based protections that were in the 14th Amendment in the National Constitution that would have been enforced against the states anyway. Well, you're mostly right about that, but there's one word here in this provision from the Texas Constitution that makes it important and makes it relevant, and that's the word sex. I remember I mentioned this was ratified in 1972 and was brought about and was ratified specifically as a response to the attempts in the years previous to add an amendment to our federal Constitution to guarantee non-discrimination on the basis of sex. At the national level, we did not ratify that at that point, and the deadline for ratifying the federal Equal Rights Amendment, which was a sex gender protection, has expired. And so, directly in response to the absence of a federal constitutional provision guaranteeing equality based on sex, Texas, doing a great thing, adds to its Bill of Rights the protection from discrimination on the basis of sex. So this is kind of interesting. When we think of Texas nowadays, we would not think of a state. We would not think of Texas probably as a state that would do this these days, right? This would be something California would do and Massachusetts would do, and those kind of places. It's interesting that in the early 70s, politics in Texas were slightly different, and so we do have in our Texas Constitution a protection from discrimination on the basis of sex. This slide and the next one just sort of provide the litany of federal equal employment opportunity statutes that your textbook addresses. I'm not going to address all of them. I'm going to kind of focus on the ones that seem the most relevant, most important. But it's certainly worth your time to take a look at these pages in the textbook and just kind of for the ones that I don't spend a lot of time on. check them out and sort of try to understand where they're coming from and what their purposes were and are. The first one I want to give some mention to is the Equal Pay Act of 1963. So in 1963, women who held positions comparable to positions men held with comparable responsibilities and comparable qualifications made about 59% of the compensation received by men. So women, I don't think I said that right. Women's compensation was at the level of about 59% of the compensation of men in comparable positions with comparable qualifications. And so this Equal Pay Act was an attempt to address that, basically requiring that men and women whose responsibilities were equivalent, whose qualifications were equivalent, be paid at the same rate. The rate of improvement from 1963, and by the way, the Equal Pay Act is still the law, is still very relevant today. The impact of the Equal Pay Act of 1963 has been very, very slow. I'm going to look over for a minute and read you some numbers. So by 1970, the rate was still about 59%. By 1980, we were up to 60%. By 1990, we were up to 72%. So we're making some progress now. By 2000, 73%. By 2010, 77%. And the most recent number I have is the 2018 number, which was about 82%. And so, this statutory guarantee of equal pay hasn't made anything equal. It's got us moving in the right direction, and that's a good sign. But one would expect the equal pay issue to have moved much faster than it has, and so that's a little disappointing. Hopefully we'll be at 1-to-1 sometime pretty soon. Title VII of the Civil Rights Act of 1964 is probably the most important equal employment opportunity provision of any kind. It's certainly the most important statute. I've got a few more slides coming up on Title VII specifically in a minute. The Age Discrimination in Employment Act prohibits employers from taking adverse employment actions against anyone based upon their age if they are over the age of 40. So the Age Discrimination in Employment Act is only about discriminating against people for being too old, and only about discriminating against people who are over the age of 40. If we were in a physical classroom right now, I would look around the room and with a big smile say, well, gosh, it looks like I'm the only one here who this Age Discrimination and Employment Act helps. And so I'm not looking out, and I haven't stalked y'all and found out your birth dates to find out if it's true. But I'm guessing that it's true, like it would be in most semesters on campus. This law protects me. It doesn't do you any good if you're 20, 25, whatever. It's only about people over the age of 40, and only protects them against adverse employment actions when the action is based upon their age. There's a couple more there that are addressed in the textbook, and we'll go on to the next slide. The 1978 Pregnancy Discrimination Act requires employers and other relevant actors to treat pregnancy no different than any other health condition that might interrupt one's ability to work for a short period of time. Similarly, it would prohibit employers from choosing not to hire someone who is pregnant, from taking adverse employment actions against a woman because she is pregnant. It would prohibit what was a relatively common practice at the time of not hiring younger women in particular, so women under the age of, 40-ish, based on the idea that they would want to take some time off in the future because they would be having children in the future. And so basically tells us that pregnancy, past, present, or future, is not a valid criterion on which to base any employment actions. The Americans with Disabilities Act of 1990, which has been amended several times and has a slightly different name now. I think it's the ADAA, the Americans with Disabilities Act as amended, is our first sort of comprehensive law that protects from discrimination people with disabilities. I've got a few slides on the Americans with Disabilities Act later, but the basic idea is that if one can fulfill the essential requirements of a job, and notwithstanding his or her disability, is the best candidate, or the candidate who would be selected for the job notwithstanding that disability, then the employer should not consider that disability in the employment decision, and would require the employer to make some reasonable accommodations in order to enable that person with a disability to fulfill the requirements of the position. The last one that I'll mention, just kind of in our quick summary here, is the Genetic Information Non-Discrimination Act of 2008. With the mapping of the human genome over the past few decades, which was still kind of just, when I was in college, was just sort of the idea that, oh gosh, this might happen someday, I wonder. It's happened. It tells us as employers and as HR professionals that we cannot use any information about someone's genetic identity at any point in the employment selection or retention or promotion process or anything like that. Why might you want to do that? Well, employers might want to do that, if they know that that a particular candidate has a predisposition toward heart disease based on family genetic factors. If they know that the person has a particular anomaly in their genetic code that makes them more likely to develop a particular disease in the future, employers might want to avoid those employees because of the potential effects on the cost of providing health care for them in the future. And so that's why we have this. That's why this Genetic Information Non-Discrimination Act becomes relevant. And so we'll go on and talk about a few of them. In particular. The Civil Rights Act of 1964 is the landmark legislation that grows out of the American Civil Rights Movement of the late 50s and early 60s. Title VII specifically is about the employment relationship, and provides a general prohibition against taking adverse employment actions against someone based upon certain characteristics. And so let me just read you what this is the language from the statute. So it makes unlawful failure or refusal to hire or to discharge any individual or otherwise discriminate against any individual with respect to compensation, terms, conditions, or privileges of employment. So you can see we can't take any adverse action against them, not hire, discharge, can't pay them less, can't make their terms of employment worse somehow, that they don't get benefits and comparable employees do get benefits, can't affect the working conditions, can't have all your light-skinned people working in offices and all your dark-skinned people working outside. That's the idea of this first one here. The second piece of the operative part of Title VII is a prohibition against limiting, segregating, or classifying employees or applicants for employment in any way that would deprive or tend to deprive them of their equal opportunities, or otherwise adversely affect their status as an employee. So prohibits limiting, segregating, or classifying employees or applicants in any way that would tend to adversely affect their ability to derive benefit from the employment relationship with you. So the next slide talks about who this protects. So the groups of people protected under those provisions on the previous slide by Title VII of the Civil Rights Act, we call these the protected classes. And so the protected classes under the Civil Rights Act are race, color, religion, sex and gender, and national origin. So the prohibitions of Title VII require that we don't take any adverse employment action against anyone based on any of these criteria: race, color, religion, sex, or national origin. There's been some very important recent news on the sex front, if you will. On June 15th of 2020, the Supreme Court issued a very important decision that clarified that the Title VII's protection with respect to sex also applies with respect to sexual orientation and gender identity. If you've been in my employment law class for the past, any of the sections for the past couple of years, we've been studying this case in advance of the decision coming, just because it's been so, it was known that it would be such an important decision. It was quite a surprise that the court decided the way they did. The vote was actually 6-3, and the Supreme Court prognosticators predicted a 5-4 decision one way or the other, with the 4 liberals obviously on the side of understanding sexual orientation and gender identity to be a part of sex, the 4 conservatives being on the side of not understanding sexual orientation and gender identity to be part of the category of sex, and with the relatively conservative Chief Justice kind of in the middle. And we just, everyone sort of thought that whichever way the Chief Justice goes would be, would make the 5-4 one way or the other. It turned out that one of the hard-right conservatives, Justice Gorsuch, actually jumped onto the liberal side and agreed that conceptually sexual orientation and gender identity were manifestations of sex, and so should be protected as sex discrimination the same way that gender standing alone would. It's a fascinating case. The case is called Bostock versus Clayton County, Georgia. Look it up, check it out. If you ever want to sit and chat about it, I'd love to sit and chat with you about it. It's been kind of the main academic thing I've been working on for the past few years. Part of what Title VII of the Civil Rights Act of 1964 did was to establish the Equal Employment Opportunity Commission. So the Equal Employment Opportunity Commission is a quasi-independent federal agency. So it's an agency, so it's part of the executive branch. The president appoints the commissioners, the commission's commissioners, but we say that it's quasi-independent because it doesn't report to the president in the way that the Department of Justice does or the Department of State does. The commissioners have a level of independence that's not true of all of the administrative agencies. So the Equal Employment Opportunity Commission is tasked with enforcing virtually all equal employment opportunity law at the federal level, at the national level. Arguably, the where they have their most impact is through investigating and attempting to resolve complaints of discrimination. There's actually an interesting process that an employee or job applicant needs to go through if he or she believes that they were discriminated against in the employment relationship somehow. You can't just go run to court like you can if you're wronged in most ways. First, before you can file a lawsuit against that person that company or firm that you think discriminated against you, you first have to file a complaint with the EEOC. If the EEOC agrees that you've likely been unlawfully discriminated against, that's great news for you because now not only do you get to sue, but the Equal Employment Opportunity Commission is going to sue for you. They're going to be your lawyer. And so that's great news. If you submit a complaint to the EEOC and they do not agree with you that there's a substantial basis for thinking you're discriminated against, it's not the end of the road though. You get a letter from them that's called the Right to Sue letter. And so basically it's a letter that says, we don't think you're right, but we investigated, you did your thing, we did our thing, and so now you have the right to sue if you want to. And so you get to sue, but you still got to go get your own lawyer and pay for that maybe, and pursue that on your own. So that's probably where the EEOC has their most impact is through their investigations. They do nonetheless have another number of other ways that they enforce EEO laws. They monitor organizations' hiring practices. And so for very large employees, that involves collecting data from them and analyzing those data with respect to who the firm is hiring and who the firm is not hiring. And they also issue guidelines which sort of provide examples and explanations and kind of specifics of how the language of the equal employment statutes and regulations can and should be interpreted in order for firms to comply with equal employment opportunity requirements as best as they can. Discrimination under these EEO laws kind of comes in two different flavors. The first is disparate treatment. The second is disparate impact. So this slide looks at disparate treatment discrimination, and the next slide we'll take a look at disparate impact discrimination. So unlawful discrimination based on disparate treatment is when the employer treats differently individuals based on the individual's race, color, religion, sex, national origin, age, or disability status. So you see this covers both Title VII, not both, but covers Title VII, the Age Discrimination and Employment Act, and the Americans with Disabilities Act. Disparate treatment discrimination is generally intentional. It's, for the most part, it's the case that if you're being accused of disparate treatment discrimination, it's most likely that disparate treatment discrimination only happened if you intended for it to happen. There certainly are some exceptions where it could happen unintentionally, but it's almost always intentional. And so the disparate treatment discrimination could happen anywhere in the employment life cycle. Could happen with respect to any of the HRM functional areas. It could happen in recruiting and selection. It could happen in compensation and benefits. It could happen just about anywhere. Your textbook, for some reason, calls out questions and decision criteria, questions and interviews and decision criteria. And I guess that makes sense because that's where this happens a lot, where a firm. An individual who's on a selection committee, whatever, for some reason doesn't like people who belong to a certain group, and so they choose to discriminate in that way. And so we have this idea that when we make employment action decisions, we only make them on bona fide occupational qualifications. And so BFOQ, I don't normally put the initialisms or acronyms in parentheses because they're kind of obvious, but this one didn't seem obvious to me, so I put it on there. Bona fide occupational qualifications. So what's a bona fide occupational qualification? It's when the qualification is an absolutely necessary qualification for performing the job. is a bona fide occupational qualification. BFOQs are limited to policies directly related to workers' abilities to do the job. So what does that tell us? Well, it tells us that it's not that we can never discriminate against any of these factors, but if the situation comes up where one of these factors is a bona fide employment qualification, bona fide occupational qualification, discriminating against that person on that basis would actually be legitimate. So what might be some examples where one could legitimately discriminate against someone based on these characteristics? Well, let's look at age. Imagine that you were hiring a commercial airline pilot. I think it's the case that in order to get a license to be a commercial airline pilot, you have to be above a certain age and below a certain age. I think once you hit a certain age, there's a cap, right? You can't be a commercial pilot if you're over 70 or whatever. That would be legitimate, right? If you're looking for a pilot and they're too old to renew their license, perfectly legitimate to discriminate against them on that basis. Do a national origin example. Imagine that you're a defense contractor. You make weapons or whatever military stuff that you make, and you're looking to hire someone who would need to have a particular security clearance. And so different security clearances have different requirements. There are certain security clearances that absolutely require U.S. citizenship. Not just legal right to work in the United States, but require U.S. citizenship. And so if you're looking to hire someone to work on a defense contract that requires someone to be of a particular national origin, then absolutely that would be a basis for discriminating. What about religion? Let's say that you're hiring the rabbi for your temple. Is it legitimate to require your rabbi actually be Jewish? Well, yes, of course, you should require your rabbi to be Jewish. The more interesting religion cases are not when you're hiring a rabbi at the temple, but when you're hiring an administrative assistant at the temple. Is it legitimate to require that person to have the religion of the group? Well, I don't know. Maybe not. What about sex? Are there legitimate situations for discriminating based on sex? Absolutely. If you're hiring the locker room attendant for the women's locker room, you can absolutely, requiring the person to be a woman is absolutely legitimate. The concerns about modesty and creepy guyness or guy creepiness would certainly allow you to require that the women's locker room attendant be a woman. So there are a few examples of disparate treatment, situations where there might be an exception, where there really might be a legitimate basis for discriminating based on one of these characteristics. Discrimination under these EEO laws kind of comes in two different flavors. The first is disparate treatment. The second is disparate impact. So this slide looks at disparate treatment discrimination, and the next slide we'll take a look at disparate impact discrimination. So unlawful discrimination based on disparate treatment is when the employer treats differently individuals based on the individual's race, color, religion, sex, national origin, age, or disability status. So you see this covers both Title VII, not both, but covers Title VII, the Age Discrimination and Employment Act, and the Americans with Disabilities Act. Disparate treatment discrimination is generally intentional. It's, for the most part, it's the case that if you're being accused of disparate treatment discrimination, it's most likely that disparate treatment discrimination only happened if you intended for it to happen. There certainly are some exceptions where it could happen unintentionally, but it's almost always intentional. And so the disparate treatment discrimination could happen anywhere in the employment life cycle. Could happen with respect to any of the HRM functional areas. It could happen in recruiting and selection. It could happen in compensation and benefits. It could happen just about anywhere. Your textbook, for some reason, calls out questions and decision criteria, questions and interviews and decision criteria. And I guess that makes sense because that's where this happens a lot, where a firm. An individual who's on a selection committee, whatever, for some reason doesn't like people who belong to a certain group, and so they choose to discriminate in that way. And so we have this idea that when we make employment action decisions, we only make them on bona fide occupational qualifications. And so BFOQ, I don't normally put the initialisms or acronyms in parentheses because they're kind of obvious, but this one didn't seem obvious to me, so I put it on there. Bona fide occupational qualifications. So what's a bona fide occupational qualification? It's when the qualification is an absolutely necessary qualification for performing the job. Is a bona fide occupational qualification. BFOQs are limited to policies directly related to workers' abilities to do the job. So what does that tell us? Well, it tells us that it's not that we can never discriminate against any of these factors, but if the situation comes up where one of these factors is a bona fide employment qualification, bona fide occupational qualification, discriminating against that person on that basis would actually be legitimate. So what might be some examples where one could legitimately discriminate against someone based on these characteristics? Well, let's look at age. Imagine that you were hiring a commercial airline pilot. I think it's the case that in order to get a license to be a commercial airline pilot, you have to be above a certain age and below a certain age. I think once you hit a certain age, there's a cap, right? You can't work if you're over, can't be a commercial pilot if you're over 70 or whatever. That would be legitimate, right? If you're looking for a pilot and they're too old to renew their license, perfectly legitimate to discriminate against them on that basis. Do a national origin example. Imagine that you're a defense contractor. You make weapons or whatever military stuff that you make, and you're looking to hire someone who would need to have a particular security clearance. And so different security clearances have different requirements. There are certain security clearances that absolutely require U.S. citizenship. Not just legal right to work in the United States, but require U.S. citizenship. And so if you're looking to hire someone to work on a defense contract that requires someone to be of a particular national origin, then absolutely that would be a basis for discriminating. What about religion? Let's say that you're hiring the rabbi for your temple. Is it legitimate to require your rabbi actually be Jewish? Well, yes, of course, you should require your rabbi to be Jewish. The more interesting religion cases are not when you're hiring a rabbi at the temple, but when you're hiring an administrative assistant at the temple. Is it legitimate to require that person to have the religion of the group? Well, I don't know. Maybe not. What about sex? Are there legitimate situations for discriminating based on sex? Absolutely. If you're hiring the locker room attendant for the women's locker room, you can absolutely, requiring the person to be a woman is absolutely legitimate. The concerns about modesty and creepy guyness or guy creepiness would certainly allow you to require that the women's locker room attendant be a woman. There are a few examples of disparate treatment, situations where there might be an exception, where there really might be a legitimate basis for discriminating based on one of these characteristics. We looked at the first type of discrimination on the previous slide, which was disparate treatment impact, where usually intentionally an employee or an applicant or someone with respect to their employment relationship is treated adversely because of one of those characteristics: race, color, religion, gender, disability, whatever. Disparate impact discrimination is quite a bit different. So disparate impact discrimination is not about the firm treating people differently because of those characteristics. It's instead when the firm has some policy or some practice or makes some decision that seems neutral, seems not to treat people differently based upon any of those characteristics, but it turns out that it does. And so disparate impact analysis requires analysis of a group of job applicants or a group of employees or a group of people implicated, whereas disparate treatment analysis can just be one person, right? Just one person who gets treated adversely because of one of those characteristics. We say that disparate impact discrimination is generally unintentional. And I think that's probably right, that it is generally unintentional. There are very obviously, ways to create rules that seem neutral but are intended to discriminate. I'll just give you one example. It's not at all uncommon for municipalities, particularly outside of Texas, but I think there are a few in Texas. It's not at all uncommon for municipalities to require that employees, that people who work for the city, have to live in the city. This makes sense for a number of reasons in different contexts. Lots of municipal employees are related to emergency services, police, fire, etc. Requiring them to live in the city makes them more accessible if they need to be called in an emergency. Requiring city employees to live within the city also sort of invests them in the city in a way that people who don't live there are not invested. You're actually hearing this a little bit right now in the police reform proposals that are around in various places. I grew up in Chicago. In Chicago, all city employees have to live within the city, and so if you get offered a job by the city, you have to either live there from day one, or within the first however many months of your employment, you need to move into the city of Chicago as an absolute requirement. So it's a legitimate thing, right? Let me tell you about one particular city, though. There's this city in Dallas County called Highland Park, Texas. Highland Park, Texas is 94.4% white, 0.5% African American, 2.8% Asian, 1% other. So let's imagine that Highland Park adopted one of these policies, that if you work for the city, you've got to live in the city. These policies have been around for a long time. We've never thought of these policies as being disparate impact kind of policies. They almost always do not have a disparate impact effect. But let's imagine that Highland Park adopted this. So in order to work for the city, you've got to live in the city. So that means my pool of applicants is going to be 95% white, right? And it almost certainly means that my candidates who rise to the top are not going to be African American, not because there aren't African Americans who live in Highland Park, but because the African Americans who live in Highland Park don't want to work for the city. It's most likely that they're not going to be Pacific Islanders who represent 1% of the population in Highland Park, not because they're not qualified, but because they've got better jobs or whatever. And so having a rule in a city like Highland Park that in order to work for the city, you've got to live in the city would have a disparate impact on African Americans, would have a disparate impact on Asian Americans, would likely have a disparate impact on Latinos and Latinas. Not because the rule itself is a bad rule, but because the effect that the rule is going to have is going to be detrimental. It's not that we're treating African American job applicants differently. We're treating them the same. Everybody who lives in the city gets treated equally. Everybody who doesn't live in the city gets treated equally, right? So we're not treating them differently. It's just that the rule that we've come up with happens to have this disparate impact, this unreasonably disparate impact. So how much of a disparate impact is too much? Well, this next bullet sort of tells us what the first test is. The first test is something called the 4/5 rule. And the 4/5 rule, it's not an absolute black and white test. It doesn't, if you are in compliance with the 4/5 rule, that doesn't mean that you're okay. If you violate the 4/5 rule, that doesn't mean that you've discriminated. It's just sort of a starting place for the analysis. And so the 4/5 rule tells us that we should have a hiring rate for relevant minority groups that is no less than 80% of the hiring rate for the majority group. If the hiring rate for a particular minority group is less than 80%, less than 4/5, that's a sign that we might have disparate impact discrimination. If the hiring rate is 4/5 or higher, it's a sign that we likely do not have a disparate impact discrimination situation. It's not an absolute rule. It's not just black or white. 4/5 is, 81% is okay and 79% is not okay. No, it's nothing like that. It's just sort of a beginning place to look at the analysis, to sort of see how this particular employment action is playing out. So we start with the 4/5 rule. The next slide will show you how to calculate the 4/5 rule. I'm almost certain there'll be at least one question on the test asking you to calculate a 4/5 rule, so you might want to spend some time with that. Not discriminating against applicants or employees on the basis of these protected characteristics is the first piece of the EEO requirement. The second piece is to provide reasonable accommodations to applicants or to employees, or by the way, to college students who are able to perform the functions of a job with a reasonable accommodation. In other words, they're able to do it, but they just need something about it tweaked a little bit. The most common of these of the protected classes for which a reasonable accommodation is often relevant are disability and religion. And so what does that mean? Well, so let's imagine that your position requires someone to use a personal computer, right? And most of us interface with a personal computer through the use of a monitor, right? A display monitor. Well, imagine that someone is visually impaired and is unable to see well enough to see a monitor. A reasonable accommodation would be a screen reader, right? The employee's provided with a screen reader. No, not the crappy screen reader that comes with Office or with Windows, whatever it comes with. A real good screen reader, right? Would that be a reasonable accommodation? Yeah, most likely, right? So that would just be one example. So kind of a little tweak to the job, so that the employee is able to perform the duties. The reasonable accommodation thing also comes up periodically with religion, and there are a number of world faiths where employees are required to fulfill certain obligations on certain days or at certain times of the day. So imagine you have an employee who's a Muslim who prays Salat 5 times a day. Most likely during the workday, that's going to come up at least once or twice, depending upon the length of one shift. And so the employee says, hey, can I have however many minutes at this time and this time to pray Salat? And just because it's something that my faith requires, it's important to me that I want to do. Is that a reasonable accommodation? Yeah, most of the time, of course. Does it mean that that employee works less than everybody else? Well, no. That time that they're away to do prayer or whatever is time that needs to be recovered somehow. So you work something out with the employee, right? Maybe it's that I take a 30-minute lunch instead of a 1-hour lunch. Maybe it's that I don't get the typical morning and afternoon breaks that everybody else does. Maybe it's that I come in 15 minutes early and leave 15 minutes late, or I leave 30 minutes late, or whatever. If the religious obligation is with respect to an entire day or a longer period of time, other than the short period of prayer in Salat, it might be instead that hey, I'm an Orthodox observant Jewish person. I don't work on the high holy days. Well, of course, we're going to grant that as an accommodation, assuming that there's not a reason that we shouldn't, and we'll get to those in the next bullet. Does that mean it's just a free off day for you? Well, no. We allow the employee to take a vacation day or a personal day. The more generous employers will even allow them to take a sick day. If you don't have any of that stuff, then it's just a day without pay, or you reschedule it somehow if you can. The possible exception to the obligation of providing reasonable accommodations is if the accommodation would require a significant expense or significant difficulty to the employer. And so an accommodation is reasonable if it does not impose an undue hardship on the employer. And it might be the case that a reasonable accommodation for one employer would be an unreasonable accommodation for a different employer. All right. Imagine that your office is a third floor walk-up. You're a small business. Your office is a third floor walk-up. No elevator. Prospective job applicant in a wheelchair. Is it an undue hardship to ask a small business to install an elevator? Yeah, it probably is. Would it be an unreasonable accommodation to ask a university like UTA to install in one of its big, grand 2-story buildings an elevator? No, that probably wouldn't be unreasonable, right? The firms are situated differently. And of course, employers always think that it's an undue hardship, right? And so it's not just what the employer thinks that matters. And obviously, the enforcing agencies will get involved and help resolve disputes to the extent they can between employers and employees with respect to these accommodations. There are obviously a great many reasons why it's an important value to your firm to protect all of your employees, all of your customers, everyone involved in your operation from sexual harassment. Because you value the people with whom you're in a business relationship as human beings, because you respect their ability to make decisions about themselves and their own sexuality, and not be obliged to the whims of others. There's lots of reasons. from an equal employment opportunity perspective, the reason is that sexual harassment is a type of gender discrimination. In virtually every case, and really in every case that I can think of, a sexually harassing act or acts is committed against someone because of that person's gender, right? Straight people don't go around harassing people of the same sex. Gay people don't go around sexually harassing people of the opposite sex, right? So sexual harassment is gender discrimination, is sex discrimination. So what might include? Well, there's lots of things it could potentially include. Most often it will include unwelcome advances, requests for sexual favors, other verbal, physical contact that's unwanted by the person receiving it. And here are the criteria that make it more than creepy, that actually make it sexual harassment. So it becomes sexual harassment when any of these three things come to be. When submission to the conduct is a condition of employment, I'm going to fire you if you don't, blah, blah, blah. When submission to a rejection is a basis of employment decisions, hey, you want this promotion, hey, you want a good schedule, right? Or where the conduct interferes with the employee's ability to do his or her work, or his or her performance doing his or her work. So, in the list of things above, an unwelcomed advance, simply one coworker asking another coworker to go out on a date. Is that sexual harassment? Well, submission to the conduct of condition of employment? No, they're coworkers. Basis of employment decisions? No. Interferes with the employee's work performance? If the person just asks once and isn't creepy about it and doesn't keep asking over and over again, does that interfere with either employee's work performance? No, probably not. However, if that unwelcome advance comes over and over again and comes with flowers on the person's desk every morning, and comes with weird sexual emails over and over again, well, yeah, at that point it does interfere with the colleague's work and the colleague's work performance, right? Requests for sexual favors, well, when they come from an authority, from a supervisor figure within the organization, then it's often the case that either the conduct is a condition of employment, or the employee very reasonably perceives it to be a condition of employment. Submission or rejection as a basis for employment decisions, well, it either is, or it could, when it comes from a supervisor, it very easily could be, right? Verbal sexual contact, similarly, when the boss comes and starts rubbing your shoulders all creepy while you're sitting at your desk, that's not right. That's weird. That's of course sexual harassment. It interferes with the employees to do the work. It creates the perception that if I squirm away, that I'm jeopardizing my career. So sexual harassment comes in two different kinds. There's hostile work environment sexual harassment, and there's quid pro quo sexual harassment. So hostile work environment is generally when it's the conduct that interferes with employees' work performance, where something that's happening in the environment could be because of a supervisor, could be because of a coworker, could be because of a subordinate, could even be because of a contractor or a client or a vendor or anything, that happens with such regularity and is so extreme that the work environment as it exists is a hostility toward the person being harassed. Hostile work environment sexual harassment does not come from a single dirty joke. It does not come from someone at work, or a coworker, asking you out on a date once. That doesn't make it a hostile work environment. Becomes a hostile work environment when it starts happening repeatedly, when it gets creepy, and when it really does interfere with one's ability to do one's job. Quid pro quo sexual harassment, on the other hand, for those of you that didn't take Latin in high school, quid pro quo means this for that. Quid pro quo is this for that. Quid pro quo sexual harassment, on the other hand, does create sexual harassment with just one incident, with just one example. And so, imagine that you were allowed to come to campus these days, which of course we're not doing right now. Imagine you were to come to campus and came into my office and said, "Hey, Tom, I know my average in the class is 89.9, but I'm just wondering if there's anything I can do to get myself up to 90." Right? And I push myself back from my desk and with a big smile, "Yes, I know, it'll only take you about 90 seconds, and we can change that 89.9 into a 90, right?" Of course, I wouldn't do something creepy like that, but imagine that I did. Just that one time, just that one thing, it's sexual harassment that first time, right? Because it would be a this for that. You do whatever that this is that I had in mind, and I won't tell you what I had in mind. You can imagine for yourself. It's that this in exchange for the that. The sex act in exchange for the higher grade, or the sex act in exchange for the promotion, or the sex act in exchange for whatever value. So sexual harassment is sex discrimination, includes all of those things we talked about. Important to recognize this difference between hostile work environment, which can come from anyone in the organization, usually requires multiple experiences of something, and it needs to be extreme to some extent. Quid pro quo is this for that. Quid pro quo only has to happen once. It's sexual harassment the very, very first time, when someone asks for something of a sexual nature in exchange for something related to the employment relationship. So employers have the obligation to not only take action when sexual harassment happens, to not only take action against the organizational actors who are doing it, but also have an affirmative responsibility to prevent it before it happens. And so that means several things, right? It means in part developing and communicating a sexual harassment policy. The good news is you don't need to write it, right? Find a company that's like yours and steal theirs, because they probably had a lawyer write it for them, If you're a big company and you've got some resources, then hire your own lawyer to write it for you. But have a policy, make sure employees know about the policy, and enforce the policy. Another part of preventing sexual harassment is training employees to recognize the breadth of behaviors that are often harassing to people, and so this should be a part of a firm's regular training cycle, regular training activities. Whatever the training plan for the whole firm is, it should include training on preventing, on recognizing and preventing sexual harassment on some regular basis. Once a year, I think, is what we do at the university. That might be a bit much in some places. Once every 2 years, once every 3 years, that all sounds reasonable to me. But if it's, if the firm is one that has a whole lot of interaction with the public, if it's maybe a firm that is in a business where sexual harassment, or an environment, I should say, where sexual harassment is more likely to happen. I'm thinking of bars. I'm thinking of Hooters. I'm thinking of strip clubs. Exotic, whatever we call exotic dance clubs. I'm thinking of, kind of places like that. Then it might need to be even more often than once a year. And finally, not finally, but a third thing, providing some mechanism for employees to be able to make complaints about sexual harassment, and to have some protection for their position against retaliation, for them against retaliation from other employees. In the world of education, that we have Title IX of the Education Amendments that provides everyone in the educational community, particularly higher ed community, but it also goes down to elementary and secondary schools as well, an elaborate mechanism for these complaints to be made, to be investigated, to be adjudicated, that comes with some very specific protections for actually both accusers and accusees alike. So those are just a few thoughts. If you'd want to talk about this some more, there's a lot of good stuff out there on preventing sexual harassment before it happens. Well, of course, you should want to comply with all of the equal employment opportunity requirements, because it's the right thing to do, because it's the way decent human beings treat each other, because it's fair. But if you're not turned on by those things, instead you're turned on by as great a profit margin as possible, then think about this. Most firms nowadays have come around to viewing a diverse workforce as a competitive advantage. In other words, as something about your operation that can make you better than your competitors. In other words, it is almost certainly the case for almost all firms that a diverse workforce will make them better. All right, they will be better at doing the work they do. And in the intro management classes, as you recall, we go into this to some greater extent. And so it's legitimate because the value of diversity is not only a social good, has not only social benefits, but also has business benefits to the firms. Some organizations may actually practice a type of affirmative action that encourages underrepresented groups to apply for positions, encourages them to get into the pool of applicants, that invites them into training opportunities that they might not know exist. Doesn't mean that organizations should start hiring unqualified people because they want to look diverse. No, that's not right either. But to be able to take some actions in order to increase the ranks of diversity throughout the organization, and particularly at the higher levels of the organization, where some of the traditionally underrepresented groups remain underrepresented. Also, organizations that value diversity might even try to reward or promote employees who go out of their way to respect others, go out of their way to do work that demonstrates the organization's value of diversity, and that seems perfectly legitimate. So the big turn now. So the first chunk of this module was about equal employment opportunity. Now we can move into the second chunk, which is about workplace health and safety. So the Occupational Safety and Health Act, OSHA, which is usually pronounced OSHA. OSHA is the U.S. law that authorizes the federal government to establish and enforce occupational safety and health standards for all places of employment that engage in interstate commerce. What places of employment engage in interstate commerce? Virtually all of them. If you have a website, you are engaged in interstate commerce as far as I'm concerned, because you're putting your message out there to everybody. So just like we have the Equal Employment Opportunity Commission that enforces equal employment opportunity law, the Occupational Safety and Health Administration within the Labor Department is responsible for inspecting employers, applying health and safety standards, levying fines for violations, and doing periodic investigations related to serious injuries that happen in workforces. Like equal employment opportunity, the protection of employee safety and health is regulated by the government in this way, right? And so this OSHA Act, the Occupational Safety and Health Act, is by far the most comprehensive U.S. law regarding worker safety. Under OSHA, there are general duties and specific duties. Employers have a general duty to provide employees with a place of employment that is free from recognized safety and health hazards. They need to inform employees about any hazardous substances that are present in the workplace. They need to maintain and post publicly records of accidents and illnesses and comply with all of the standards that are relevant to specific hazards in specific occupations. In addition to complying with OSHA regulations, employers will often establish on their own safety awareness programs that are designed to instill an emphasis on safety. Why do they do this, even though it's above and beyond what the law requires? Well, for obvious reasons. They do this because they don't want their people to get hurt. They don't want to have to pay the medical bills for their people when they get hurt. They don't want all of the negative publicity that comes with big workplace accidents. They may identify and communicate hazards through a variety of different job hazard analyses and or the technique of operations review, which your textbook goes into in some depth. They may adapt communications and training to the needs of different employees, which absolutely makes sense, right? Employees who are in operations need to know a whole lot more about safety than employees who are in accounting, probably, I think. They may vary it based on experience levels so that more safety information is provided to more junior employees. They might provide different safety information to employees who work in different plants that have different types of equipment, sorry. Some employers will even go as far as to create incentive programs that reward safe behavior, so that there might be a group bonus when the factory floor goes 100 days without a reportable injury. There might be individual bonuses for employees that identify potentially dangerous situations to the company and work with the company to get the safety issues resolved. So even though we can think of workplace health and safety as sort of an obligation, I think it's fair to say that most firms really do view it as something that's in their best interest, both in the short term and in the long term. I realized that I kind of overtalked that last slide, and in doing so, I think I kind of usurped this slide. So I'll just be quick on this slide. General duty clause: employers provide a place of employment that's free from hazards that will cause or are likely to cause death or serious physical injuries. And the second part of the general duty clause is that employers must keep records of workplace-related injuries and illnesses, and they must make publicly available an annual summary of them. Now, in the olden days when I started working, this annual summary would be posted in the HR office somewhere, and no one would ever see it, and so it didn't matter much unless the numbers were so bad that people looked into it. Nowadays, most firms will post it on their employee intranets, and some will even make it more available on the internet. So here are some of the specific rights that employees have under the Occupational Safety and Health Act. Employees have the right to request that OSHA conduct an inspection of either the firm's permanent facility or a temporary facility that the firm is working at. And so, if it's a construction firm and they've got a site that they don't own, but they're working there and controlling during the time they're working there, an employee can ask OSHA to do an inspection of that site as well. During that inspection, they can request having one of their representatives present at the inspection. That's usually an attorney, or I guess it could be maybe someone involved in a workers' compensation adjustment or something like that. Employees have the right to have dangerous substances that are present at the work site identified for them. This is done, I think, in all situations. It's been every situation I've ever worked in. I think in all situations, this is done through material safety data sheets, MSDSs. And so MSDS is a document that's a number of pages that's prepared by the manufacturer of the substance, that lays out exactly what the substance is, exactly what potential dangers to health, wellness, and safety are presented by the existence of the substance in the workplace. I've gone ahead and given you a link there to the MSDS for just Clorox regular bleach, in case you want to check it out to see what they look like. And so, we all know what Clorox bleach is, right? It's regular bleach. The MSDS for Clorox is 10 pages long, right? So imagine when there are more dangerous chemicals, more substances that the general public knows less about, how detailed these MSDSs must be. At work sites, at the primary work site, these MSDSs are usually, they're usually printed on paper, and packed into a big old binder that's sitting somewhere, usually near the eye wash station, but sitting somewhere, so that people can know where they are and can access them if they want to. No employees ever look at them in advance of when, in advance. They only get interested in them after they've been burned, or after they've been exposed, or after whatever. I think it's the case that most of these are also available on employee intranets. It's certainly the case that manufacturers make them available on their publicly facing internet, just because that they need to provide them to employers who use them. Also, employees have the right to be promptly informed about their exposure to hazards, and to be given access to records regarding that exposure. And employees have the right to know about their employer's violations of any OSHA rules. And so, just like the employer will post its injury and illness history, usually on an annual basis, because that's what the form calls for. Just like the employer will make the material safety data sheets available, the employer also has an obligation to post its own history of found violations of OSHA rules, and so another incentive for employers to avoid breaking these rules in the first place. The impact of the Occupational Safety and Health Act on workplace safety has been incredibly significant. It's truly a government regulation success story. And I know there's some of you on the other side of the political spectrum who will disagree with me on that, because the government never does anything right. But I'm convinced this is one area where government regulation has really worked well. It has raised the level of awareness of occupational safety, particularly among the industrial firms and the production and manufacturing sectors. We've seen a constant combined rate of illnesses and injuries decrease over time, an increase in the number of claims of retaliation against employees who happen to report injuries. This is possible because workers are more aware of their rights and are able to file complaints online. By the way workers used to be told about how to make a complaint was to get a complaint form. And while it was true that complaint forms were available everywhere before the internet, they were at public libraries, they were at City Hall, they were everywhere. Workers were told they were available in the job superintendent's office, right? So that means you had to walk past your boss's boss in order to get a form to complain about your company to the government, right? And so obviously very rarely did that happen. There are lots of employers and employees who behave, who do certain actions or engage in certain work that is not directly regulated by OSHA, and there really isn't a secondary health and safety enforcement agency, and so in those cases, it's the responsibility primarily of the employer to figure out how to ensure health and safety there. In some of these fields, there are trade groups, trade agencies, people who all work in the same industry, who agree on standards themselves, and that's often helpful to others who work in the industry. So there's a quick introduction to workplace health and safety to follow up on our equal employment opportunity stuff, and so hope this module was useful to you, and I will see you soon.